Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law Section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law. Casual listeners want to dip their toes into these pools and are curious to hear what the experts in these fields are thinking. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Pricing Conduct Committee of the Antitrust Law Section. Today's episode will tell you everything you need to know about platform pricing. Digital platforms that bring together buyers on one side and sellers on the other have become ubiquitous in our modern day, always online life, whether they're for fun, like Facebook or app stores, or for buying things we want, like credit card payment networks or Amazon. The way these platforms price their goods and services has made some of the biggest and most successful ones, companies like Meta, Google, Amazon, and Apple, the subject of major antitrust enforcement cases around the world. But the idea for this episode for me started with a question that I received years ago when a friend asked, are mergers ever good for consumers? They always cut something or raise prices. Now, there's a lot baked into that question, so if the defense bar listeners just relax for a second, but it has stuck with me because it really highlights the way that some things that make sense to us just sound off when you go say it outside, and makes you realize that some of the ways of thinking that have become ingrained for us in our cloistered world sound really strange to family when you're sitting around the Thanksgiving table and they're asking, so the government is going after this company that gives me this cool service for free or lets me return just about anything, but you think this other company that seems to have super high prices all the time isn't a problem at all? And I was having a conversation with the economist Tasneem Chipty about this, and she said, there's so much talk about platform these days that I want to do a show where we explain to people how we in antitrust look at platforms and how we think about pricing, not just platform pricing, but pricing in general. So we decided to do an episode telling you everything you need to know about how to think about whether the price of something is illegally high and whether digital platforms are pricing anti-competitively. To walk us through this discussion today are two renowned antitrust economists, Tasneem Chipty and Michael Katz. Tasneem Chipty has a degree in economics from Wellesley College and a PhD from MIT. She's the founder of Chipty Economics, LLC, and prior to that, the founder and managing principal of Matrix Economics. She has served as a testifying expert in numerous antitrust trials, including as an expert witness for the Department of Justice. She recently testified on behalf of the United States during the remedies phase of the Google search case. Michael Katz has a degree in economics from Harvard and a PhD from Oxford. He is a professor emeritus at the Haas School of Business and the Department of Economics at the University of California, Berkeley. Previously, he was the chief economist of the Federal Communications Commission and the Deputy Assistant Attorney General for Economic Analysis in the DOJ's Antitrust Division. Tasneem, Michael, welcome.
Thanks for having us, Anant.
Yes, thanks. It's a pleasure to be here.
Michael, let's start at the very beginning with some foundational concepts about platform pricing. So first, can you just tell us, why does pricing matter?
Well, in a market economy like the United States, prices play two central roles. First, they generate incentives. They're incentives for firms to choose how much to produce and sell, and for households to choose how much to buy and consume. Generally, the higher the price, the more firms are going to want to supply, and the higher the price, the less households are going to want to demand. So we think of price as equilibrating or coming to a level that balances supply and demand. So that's one important role, generating incentives. A second one is that prices transfer wealth from buyers to sellers.
So which role matters for antitrust?
As you know, the consumer welfare standard has been the dominant approach in U.S. antitrust for the past several decades. Now, based on that name, you would think that wealth transfer is the key role because consumers are best off if they transfer less wealth to sellers, all else equal. But antitrust policy in the U.S. and in many other countries seeks to promote competition because it leads to prices that do a good job of creating incentives. The flip side of this is that we're concerned with uncompetitive prices because high prices can create misincentives for consumers to purchase inefficiently little of a good or service.
So, in other words, you're saying that high prices may lead to underconsumption. Does that mean that charging a high price is illegal?
No. In general, under U.S. antitrust law, it's not illegal for a firm to charge a high price.
But doesn't consumer welfare go down when prices go up? So, how can high prices be legal under the consumer welfare standard?
That's because the consumer welfare standard is more complicated than it sounds. It actually looks at two things to determine whether a piece of conduct is illegal.
What are those two things?
Well, first, the standard asks whether the conduct harms consumers, say by raising prices. That's the part you'd expect from the name. But second, the standard asks whether the conduct that harms consumers does so by harming competition.
Okay, so I know what it means to harm consumers, but what does it mean to harm competition?
Well, I was afraid you're going to ask that. As far as I know, there's no good general definition of harm to competition, even though the term is used again and again in antitrust. But fortunately, there are circumstances in which it's pretty clear what it means to harm competition. For example, a merger between close rivals that generates no efficiencies would harm competition by eliminating the competition between those two firms.
So I'm hearing that high prices are more a symptom rather than the disease.
Yeah, to continue the merger example, antitrust enforcers examine mergers out of the concern they'll eliminate head-to-head competition between the merging parties. This lost competition can lead to higher prices, among other things. But the higher prices don't harm competition. Instead, they're the result of harm to competition.
So can high prices be pro-competitive?
Yes. Actually, the U.S. Supreme Court has stated that charging high monopoly prices is not only not unlawful, it's actually a, quote, important element of the free market system, close quotes. The court's reasoning is that the prospect of charging monopoly prices drives firms to invest, to innovate, and to compete. So this is an example of how prices create incentives, one of the two roles we were just talking about a minute ago.
Okay, does that mean antitrust policy doesn't care about prices as such?
No, because there are times when the nature of pricing can harm competition.
Okay, so let's talk about some different pricing practices and how they might harm competition. So first, can setting prices too low harm competition?
Yeah. Now, generally, low prices are good for consumers, right? They pay low product prices, and low prices typically are legal. But setting a low predatory price to drive rivals out of business and then raise price after you've eliminated competition can be illegal under certain conditions.
And can setting prices too high harm competition?
Yes, and in a way for the same reason. The problem arises from an antitrust perspective when you're using the prices to eliminate competition. So the case where it's too high, or it could be where it's too high, is when a firm is buying an input and it pays an excessively high price in order to drive its rivals out of business by raising their costs. For instance, there was a case that went to the U.S. Supreme Court, and in that case, Weyerhaeuser was accused of driving a sawmill out of business by bidding excessively high prices for saw logs. Now, ultimately, the plaintiff lost, but the court recognized the logic of predatory bidding.
Okay, let me ask you about another pricing practice that's received antitrust scrutiny. There have been several cases in which sellers have offered quantity or bundle discounts that were alleged to be exclusionary. First, can you give us an example of this type of discount?
Yes, 3M offered its customers themselves were retailers. It offered those customers discounts that were calculated based on a customer's total purchase across a wide range of products, including Scotch tape, home care products, and other goods.
So what's wrong with 3M offering customers discounts?
The concern was with the form of the discounts and that 3M's bundled discounts distorted competition on the merits. Now, LePage's was a small company that sold a limited range of transparent tapes. LePage's argued that 3M's bundled discounts excluded LePage's from being able to compete in the sale of tape. A retailer might purchase 3M Scotch tape in order to get a bundle discount, even though the customer thought LePage's tape was a better value than 3M's tape on its own. So they felt they couldn't compete sort of tape against tape. More generally, there's situations in which competition is alleged to be harmed when a large seller offers buyers substantial discounts for buying multiple different products, the sort of bundle discount we just talked about, or for buying large quantities of a single product where the size and form of these discounts makes it difficult or even impossible for smaller rivals to compete because they can't meet all of a customer's needs. So what it does, in a sense, is it's alleged to create an artificial advantage to being a big company.
Okay, thank you. I want to shift gears for a minute. We economists typically focus on efficiency and incentives. Does the concept of fairness come into play in antitrust enforcement?
Yeah, to varying degrees. So first, it comes in at a very general level. I mean, one of the rationales for antitrust concern with protecting competition is that competition is viewed as a process that generates fair prices and fair outcomes, because no buyer or seller has an unfair advantage, in contrast, say, to the case where you have a monopoly seller, so people have no choice. Second, there are particular statutes that deal expressly with the notion of unfair competition, such as Section 5 of the FTC Act, which prohibits quote-unquote unfair methods of competition, and the Robinson-Patman Act prohibits some types of price discrimination, in part out of concern for fairness.
Beyond the general rationale, are there other fairness concepts that could provide useful guidance for antitrust enforcement more broadly, that is outside of the context of a Section 5 or a Robinson-Patman case?
I mean, possibly, but if fairness is going to be a useful guide for antitrust enforcement, we need to have considered consistent principles of fairness. And so far, those have been lacking. So I think the best way to show you that is with a couple of examples. Consider people's views on the fairness of bundled retail prices before we were talking about bundled wholesale prices. But think about bundled retail prices. For years, some people have said it's unfair for cable television companies to sell channels in bundles rather than individually on a so-called a la carte basis. At the same time, people have also complained that it's unfair for airlines to unbundle their services and charge separately for things like checked bags, food, or bathroom access. Or considering the views on charging different prices to different groups of customers. What is perceived to be fair to one group may be perceived to be unfair to another. For example, are senior discounts fair? But what if they're viewed as youth surcharges? And even with Section 5, what constitutes unfair methods of competition is really rather vague.
Okay, so we've covered the fundamentals of the pricing part of platform pricing. Let's talk about the fundamentals of platforms. So first, what is a platform?
We see a theme here with definitions. First, we had the problem with what it meant to harm competition. And here, there's actually no consensus definition on a platform. And in fact, I worry that the courts can get too caught up in definitions rather than focusing on the underlying economic forces at work. But that said, I think that platform economics can usefully inform antitrust enforcement when the following four conditions hold. First, the firm facilitates interactions between two or more groups of users, such as bringing together buyers and sellers. Second, that the firm can set distinct prices to those different user groups. Okay. Third, the firm has market power with respect to those groups. It's another way of saying that when the firm's choosing the prices to the two different groups or two different sides, that it has some flexibility. It doesn't just take prices given. And fourth, that there's what are known as cross-platform network effects in at least one direction.
Okay, so the novel feature in your list seems to be the existence of these cross-platform network effects. So let's break that down by starting with the term network effects. What's a network effect?
A network effect arises when the value of a product or service increases as more people use it.
Can you give us some examples?
Yes, think about a peer-to-peer payment platform such as Zelle or Venmo. If you're the only one you know on a platform, you can't use it to transact with anyone. It's worthless to you. The platform becomes more valuable to you the more people around you who use it. Or also think about traditional payment platforms such as the Visa and MasterCard credit card systems. They also have network effects. There, cardholders find it desirable to hold a card issue on Visa because lots of merchants accept Visa cards. And merchants want to accept Visa cards because many buyers hold them.
Okay, now what does the cross-platform part mean in cross-platform network effects?
It really means what it says, that the network effects, the wanting to be where there's more of somebody, work going across the platform. So specifically, it means that users on one side of the platform value the presence of users on the other. Think about the difference between peer-to-peer payment systems and traditional credit card networks like Visa and MasterCard. With a peer-to-peer platform, you value having more users like yourself on the platform. By contrast, with credit card network, if you're a cardholder, you want there to be more merchants, and if you're a merchant, you want there to be more cardholders. Credit card systems have cross-platform network effects. It's going consumers to merchants and merchants across to consumers, while peer-to-peer platforms have same-side network effects. You want everybody on your side, your peers, and you want more of them. As another example, think about a ride-sharing service. Being a driver on a ride-sharing platform becomes more valuable as the number of riders increases. And riders get better service the greater the number of drivers. So with the ride-sharing platform, we're talking about cross-platform network effects.
Now, do cross-platform network effects always run in both directions?
No, I mean, many platforms, they do. The credit card systems and ride-sharing platforms, are both examples where you have cross-platform network effects running both ways. But in other instances, particularly with things like advertising-supported platforms, the network effects may run in only one direction. Thinking about advertising-supported platforms, things like newspapers or web search. And think about web search. Holding constant the number of ads to which someone doing a search is exposed, the search user typically does not care at all about how many advertisers are on the platform. Okay, so there probably really isn't a cross-platform network effect where searchers say, "Oh, I want to be where all the advertisers are." But clearly, advertisers do care about how many searchers there are. Advertisers want to be where the searchers are. So that's a one-sided cross-platform network effect.
So, Michael, how do cross-platform network effects matter for pricing?
The big thing is that when a platform's thinking about its prices, when it sets the price on one side of the platform, it has to take into account how that's going to affect what happens on the other side of the platform. Now, let's think about this in terms of an example. Say a ride-sharing service that matches riders and drivers with each other and charges them for doing so. In setting the prices to riders, the platform has to recognize that those prices are going to affect the number of riders on the platform. So far, so good. That's like, you think of with any business. But the extra feature is when the rider price affects the number of riders, that change in the number of riders is going to affect the driver's willingness to pay to use the platform's services. Similarly, when setting prices to drivers, the platform has to account for how the number of drivers it attracts will change, which will in turn affect riders' willingness to pay for the platform services. So there's a lot more for the platform to keep track of.
Okay, let's talk about the implications of cross-platform network effects on market structure. Now, as you've just explained, with network effects, a platform becomes more attractive to users as it becomes larger. That sure sounds like an upward spiral, where cross-platform network effects inevitably lead the platform to grow even larger. And that might lead to a concentrated market with only one or a handful of large platforms. Is that right?
Sometimes network effects can give rise to positive feedbacks that lead to high concentration. Indeed, some people claim that network effects generally result in winner-take-all markets and monopoly. But it's important to recognize there are also forces that can limit tipping to monopoly in the presence of network effects.
Okay, and what are some of those limiting forces?
Well, a big one is product differentiation. That is, that different platforms have different characteristics, and consumers have heterogeneous preferences about those characteristics, so that some consumers prefer to be on a platform that best suits their tastes, and that could be true even if it's smaller than a rival platform. You might think about Apple's Mac operating system versus Microsoft's Windows for PC. I mean, there are many more users of Windows, but there's some people who say, I really like, the features that Mac OS has, so I'm going to use a Mac. And, one way platforms can differentiate themselves is by specializing. So, for example, a specialized shopping site may be able to compete with Amazon for certain types of products or certain types of customers. Now, a second limiting force is that the advantage of size may diminish at some point. For example, a credit card network may have so many merchants that adding a few more doesn't make much of a difference at all to cardholders. And in fact, additional size can actually become a negative. I mean, this happens, for example, when there's same-side crowding. A seller might not want to be on an online marketplace with too many other sellers because of the resulting competition. It just becomes too intense.
Michael, why all the interest in platforms?
I think there's several reasons. One, as we've heard in the introduction, right, and we all know from everyday experience, is there are a lot of very big, important platforms, such as search platforms, mobile phone operating systems, payment networks, and social networks. And these networks affect a lot of people. Another reason is that economists have developed new tools for examining platform competition. And a final reason is there's some big platforms out there that make a lot of money, and I think that attracts attention.
The courts have been paying a lot of attention to transaction platforms. What's a transaction platform?
Well, as the name suggests, it's a particular type of platform. The U.S. Supreme Court has said that the key feature of transactions platforms is that they cannot make a sale to one side of the platform without simultaneously making a sale to the other. Now, the court came up with this definition as part of litigation involving American Express. One of the ways Amex makes money is when a consumer uses an Amex card to purchase something from a merchant. Both the consumer and the merchant need to agree to use the Amex platform in order for the transaction to occur. Online marketplaces, such as Amazon Marketplace, are another class of examples. Is here too, one of the main ways that such platforms make money is by getting a fee for each transaction that the two sides choose to complete over the platform.
And full disclosure to our listeners, both Michael and I worked on the American Express matter for the United States Department of Justice. Michael, from the antitrust perspective, why does it matter if a platform is a transaction platform?
The Supreme Court and some economists think that for important elements of antitrust enforcement, two-sided transactions platforms should be treated as if they charge a single overall price rather than separate prices to the two sides.
Okay, so let's take a simple example. Consider an online marketplace that charges buyers a commission of, say, $1 per transaction, and it charges sellers a commission of, say, $2 per transaction. So in this example, the overall price is $3 per transaction, and you say the Supreme Court would focus on the $3 fee rather than the $1 fee and the $2 fee individually. Why is that?
The court's thinking seems to be that it's the total amount, $3 in your example, that ultimately determines whether a transaction occurs.
And what do you think about that?
I think the approach would make sense if the parties jointly calculated whether their combined benefits of transacting on the platform exceeded $3, and if the combined benefits did so, then bargained between themselves to divide the fee up. Okay, in that case, what would matter is the total price, not the platform's prices to the two different sides. But in reality, there are often obstacles to such bargaining. As a result, each side determines whether to transact based on the fee that it is being charged. The buyer would consider the $1 fee in your example, while the seller would consider the $2 fee. Neither one of them would base its decision on the $3 total fee.
So what are some of the obstacles that prevent users from the different sides of the platform from bargaining with each other to undo the platform's attempt to charge different prices to the different user groups?
First, the bargaining process itself can be costly. It takes time and effort, and it requires the users to communicate with one another. Second, in situations where a platform charges a membership fee, for example, a credit card annual fee, or Amazon has a fee for being a Prime member, it's not clear how such bargaining would even take place when we're talking about bargaining at the transaction level. Finally, in several important instances, platform policies limit that sort of bargaining.
Can you give an example of a platform policy that limits bargaining across user groups?
Yes, American Express has merchant restraints that require merchants to charge their customers no more for the merchant's products when the customers use their Amex cards to pay than when they use other credit or charge cards. This rule effectively prevents merchants from bargaining with their customers over the use of the Amex platform instead of a credit card on a different platform.
Okay, we've been talking about how platforms set their own prices, but now you're talking about how a transaction platform sets policies with regard to the price a seller charges its customer on the platform. Are these policies something that antitrust enforcers are concerned about?
One is a case the U.S. Department of Justice brought against American Express, the case in which, Tasneem, you and I participated. And in that case, the U.S. alleged that American Express's merchant restraints harmed competition among credit and charge card networks. The other case is one that the U.S. Federal Trade Commission currently has against Amazon, where they're suing Amazon in part because of restrictions that Amazon allegedly places on the price that merchants can charge if they're participating on the Amazon marketplace. It limits the prices they can charge on other platforms.
So why does it matter if a platform limits the ability of users on its different sides to bargain with each other?
In the extreme, where there's no bargaining, platform users on each side consider only their own costs and benefits of participating on the platform. And as a result of this myopia, they may fail to reach a decision that's the best one from their joint point of view. So let me give you a hypothetical example to be a little bit more concrete. All right. Suppose that a buyer and seller want to transact with one another, and particularly the buyer gets to choose the payment platform, and there are two choices, either platform A or platform B. Okay, creativity is not my strong point. Further, suppose that the buyer gets $4 greater benefits from using platform A rather than platform B, but the platform A costs the seller $6 more than platform B. Okay, now in this situation, the buyer and seller's joint benefits are greater when they use platform B. Because recall, the buyer gains $4 from going on A, but the seller gains $6 from being on platform B, which is bigger. So if bargaining is blocked, however, and the buyer's not altruistic, then the buyer's going to choose platform A because the buyer gains $4. And this is so even though on average they'd be better off using platform B, right? They went to B instead. The buyer would lose $4, but the seller would gain $6.
And what difference would bargaining make in your example?
They could bargain, then the seller could agree to pay the buyer, say, $5 to choose platform B. Right? Notice that would more than compensate the buyer for the $4 loss from going to B. The $5 is bigger than the $4. So the buyer would be happy to choose platform B. And the seller would still come out ahead because the $5 it paid to get the buyer to switch from A to B would be less than the $6 extra it would otherwise have to pay to go on platform A. So in this case, the bargaining makes both the buyer and the seller better off.
So explain to us why policies that block this type of bargaining are an antitrust problem. And let's get specific. In what way did the DOJ think that Amex's policy harmed competition?
So one of the concerns was that Amex's merchant restraints limited the ability of platforms to compete on the merits by offering low fees to merchants. And I'll give you a concrete example. In 1985, Discover wanted to enter the credit card network business. Now, a key part of its planned competitive strategy was to charge low fees to merchants, which it then anticipated would give merchants incentives to encourage their customers to use Discover cards, say by giving them discounts on purchases made using Discover cards. But policies like the merchant restraints prevented merchants from doing this and throttled Discover's ability to compete on the merits using a low-fee strategy. And as a result, Discover ended up abandoning the low-fee strategy.
Okay, let's talk briefly about market definition, which is often the first stage in antitrust litigation and is frequently said to be the most important determinant in a litigation outcome. Are the issues surrounding market definition any different when dealing with a platform case?
Some are. So, for example, the presence of cross-platform network effects has led to a heated debate on whether different sides of a platform constitute two separate relevant markets or a single two-sided relevant market. This debate has been particularly sharp, and one might even say acrimonious, for the case of transaction platforms.
Okay, so let's focus our discussion on transactions platforms. Before we get into the specifics of the debate, what role does market definition play in platform antitrust litigation?
Well, I play several roles. First, it helps with the assessment of market power, which is typically a critical part of assessing whether the challenge conduct is capable of harming competition. So, for example, the choice of market boundaries will affect the calculation of market shares, and market shares are often used as prima facie evidence of market power. Second, it helps with the assessment of competitive effects by helping us identify the competitors that might be affected by the challenge conduct. And third, as a legal matter, it may determine whether we balance welfare effects across the two sides of the platform. Moreover, whether we balance can affect the plaintiff's initial burden and whether the plaintiff effectively has to rebut the defendant's pro-competitive justifications at the outset of the plaintiff's case.
So, what are the arguments for a single market?
That a transaction will occur over a platform if and only if both sides choose to use the platform to complete the transaction. So proponents of the single market view argue that the transaction is the unit over which competition occurs and that this entails both sides. Their broader rationale is that what goes on one side can affect competition and user welfare on the other. This isn't Las Vegas. Things that happen on one side don't necessarily stay there.
Okay, so do the single market advocates have a point that defining two separate markets might lead one to ignore the presence of strong cross-platform effects?
I think no, or at least that it's very much overstated. As long as you're careful, you can account for cross-platform network effects, whether you're looking at either one market or two.
If you can account for cross-platform network effects either way, why not keep it simple by defining a single two-sided market?
Because it's really not about keeping it simple. It's about getting the right answer and doing so through as simple a process as possible. And I think defining only a single two-sided market is risky for a few reasons. First, the notion of a single market with a single price fails to understand a fundamental characteristic of transactions platforms. And that is that generally the individual prices charged to the two sides each matter, right? Given that a credit card transaction takes place, the merchant would rather pay a lower fee to the network, while the consumer would rather receive a higher reward. Neither party is interested in the two-sided price per se. Now, as a consequence, the question of whether there's an increase in quote unquote the price of a transaction would lead, whether that would lead to substitution or not to other products is an almost meaningless question. The answer depends on the changes in the component prices, not just their sum. Okay. The second issue is defining a single market potentially obscures a lot of important differences between the two sides. The competitive conditions on the two sides can be really different for a variety of different reasons, including differences in product differentiation on the two sides, differences in the degree of vertical integration on the two sides, differences in user sophistication on the two sides, and having just a single market obscures that.
Well, can you give us an example of how the single market approach can present a misleading view of competitive conditions?
Yes. Under the U.S. Supreme Court's approach to defining a single relevant market encompassing both sides of a transaction platform, a firm is considered to compete in that market only if it participates on both sides. But sometimes two-sided platforms compete with rivals who are active on only one side or the other. So, for example, Uber is a platform that brings together riders and drivers, competes with Lyft, which is a similar platform. But on the rider side, Uber also competes with municipal bus systems, which are not transactions platforms. The Supreme Court's approach to market definition would fail to recognize this competition from municipal bus systems.
Is this a problem just in theory, or has this approach led to actual problems in enforcement?
That's led to actual problems. The U.S. Department of Justice challenged the merger of Sabre and Fairlogics. And if you read the court's opinion in that matter, you run into actually an extraordinary pair of statements. The court concluded, and I'm quoting here, Sabre and Fairlogics view each other as competitors. But the court also concluded, and I'll quote again, as a matter of antitrust law, Sabre and Fairlogics do not compete in the relevant market. Now, irrespective of what you think of the merger, those two views are not mutually compatible.
Okay, so where do you come out, Michael, in the one versus two market debate?
I find the arguments for two markets to be convincing. There are just too many differences in terms of competition and competitive effects that can arise between the two sides. And as I said, defining one price misses the entire story of two-sided pricing.
Earlier, you said that legally market definition may determine whether we balance welfare effects across two sides of a platform. Now, in your answer just now, saying where you came out in the one versus two debate, you didn't say anything about whether the one market approach helps us balance potential gains to users on the one side of a platform with potential losses to another group of users. Did you forget something in your answer?
No. Although the distinction matters to at least some courts, whether we define the two sides of a platform as being in one market or two has no effect on the difficulty or practicality of balancing. So in my view, this is a situation where arguments over market definition are obscuring other policy decisions, such as whether or how to balance the interests of the two sides. And those are, policy decisions that, at least from the perspective of antitrust economics, are not about market definition at all.
All right, Michael, I want to end with a set of three what I call fact or fiction questions, and I'll set them up for you. And you tell me whether it's right or what I got wrong, okay?
Okay.
All right, so the first set of questions has to do with a pricing practice known as Most Favored Nations clauses, or MFNs. Now, the FTC has alleged that Amazon requires third-party merchants to charge customers on Amazon Marketplace no more than what the merchants charge customers on any other online marketplace. Now, the FTC alleges that this policy stifles platform competition and leads to higher prices, which, of course, would, if true, would ultimately harm consumers. Now, for its part, Amazon has said that the FTC has things exactly backwards, that in fact the MFN keeps prices on Amazon down, which benefits consumers. Intuitively, it seems like Amazon has a point. It's hard to see how an MFN that says sellers can't charge more on Amazon than on another platform could be bad for consumers. So, fact or fiction? Attacking an MFN is anti-consumer because what the MFN does is guarantee that consumers on the platform with the MFN aren't charged higher prices than consumers on other platforms.
That's fiction. And the problem is that an MFN can sometimes raise the prices charged on other platforms. Suppose, for example, that a buyer-seller platform tries to compete with a dominant incumbent by charging merchants lower fees than the platform with the MFN does. Absent the MFN, we'd expect merchants to charge their customers lower prices when making purchases on the low-fee platform. This would attract buyers to the low-fee platform and make the low-fee platform even more attractive to sellers. Now, the MFN can harm competition by blocking prices from playing this incentive role. So the bottom line is that an MFN can prevent rival platforms from successfully pursuing low-fee competitive strategies. This is similar to what we discussed with Amex and Discover earlier. It's also, at least in part, what the FTC has in mind when its complaint calls Amazon's alleged MFN, quote, an exclusionary anti-discounting policy. Right? What they're saying is it's blocking discounts on other platforms.
Does that mean that MFNs are always bad?
No, actually, in some cases, MFNs promote competition. One of the leading ways is by preventing platform free riding. Marketplace platforms typically provide services that help buyers and sellers find each other and also just generally facilitate transactions. Now, suppose that a consumer can learn about a particular seller on a platform that invests in having good search tools and or certifies that the seller is reputable. But then after seeing that certification and being guided to the seller, the consumer could then go and buy from that same seller at a lower price on another platform that doesn't invest in the search and certification tools. The merchant might charge less when selling through the non-investing platform in order to induce consumers to use that platform for actual transactions. Now, to put things somewhat loosely, what's going on there is the first platform does the work, but the second platform gets the money. So the problem is that when we allow that sort of thing to happen, then platforms won't have incentives to invest in search and certification services. So in such a situation, an MFN can support platform promotional investments, by preventing low investment platforms from free riding on the investments of other platforms. Put another way, the platform that's making all the investment can put in an MFN and says to its merchants saying, look, we're not going to let you do this thing where you use us to find customers and then you go to a cheap platform that doesn't spend the money in these valuable tools, that they give you a discount because they're not making this investment, and then you lure your customers over there with a lower price. The MFN is going to block that sort of thing.
Does that mean that low quality platforms need to be blocked because of free riding?
I know, because sometimes offering cheaper, lower quality service better meets consumers' needs and actually constitutes competing on the merits rather than free riding. So what it means is we need to look at the specific facts for each case individually.
So, all right, let's move to something else. I want to talk about free goods. Some platforms make money by selling to one group of users access to another group of users. Think about general search advertisers and general search users. To increase search traffic, general search services typically let people search for free. So fact or fiction, antitrust enforcement can't properly deal with a platform that provides goods for free because free goods don't count for antitrust purposes.
That was fiction. But first of all, I want to correct the misnomer. Free goods are never or almost never free. There's an element of barter. A user is providing data, content, and or attention to the platform, which the platform can then monetize through the sale of data or advertising. Now, in your web search example, Google provides its search services to you for free because you are exposed to advertising and to allow Google to collect valuable information about you. But to answer your question, even so-called free goods count for antitrust purposes. That's because there's competition to attract consumers of these goods. So as with goods with traditional prices, there's a potential for conduct to harm competition in ways that harm users by degrading the terms of barter with the platform, such as offering lower quality free services or engaging in more intrusive data collection.
All right, you mentioned Google. Did these issues come up in the recent Google search litigation?
Yes, and there the court found that there was a market for general search services, even though the services were priced at zero. And moreover, the court found that Google's exclusive distribution agreements harmed competition in that market. Now, one thing, it's also worth noting that these same considerations apply to goods with negative monetary prices, such as credit cards that pay consumer rewards. Consumers can be harmed if competition is weakened and rewards go down or service quality degrades.
Okay, I've saved the most controversial issue for last. As we've discussed, users on the different sides of a platform can have different economic interests. And that means pricing conduct might harm users on one side and at the same time benefit users on the other side of the platform. For example, an academic study found that radio mergers benefited listeners by increasing music variety, but harmed advertisers in part because of a reduction in ad quantity. So fact or fiction, if conduct harms competition and users on one side of a platform, but benefits users on the other side, then antitrust enforcers should balance the gains and the losses to determine whether the conduct is illegal.
Whether this is fact or fiction depends on whom you ask.
Yes, but I'm asking you, Michael.
There are at least two alternatives, and I think there are arguments in favor of each one.
And what are the alternatives that you have in mind?
I think there are two polar cases. One is to use a measure of total user welfare, such as user surplus, which would entail one-for-one balancing across the sides. The other extreme would be to have no balancing. For example, one might take the position that users on each side are separately entitled to the benefits of competition. In other words, if conduct harms competition and harms one side, then that side gets a veto over the conduct.
You said there are arguments in favor of each approach. Walk us through them. What are they?
An argument for balancing is that if the ultimate aim of antitrust enforcement is to improve user welfare, then even anti-competitive conduct should not be illegal if it helps people on average. An argument against balancing is that each side's entitled to the benefits of competition. If a bank robber donates some of the money to charity, we don't say that robbing the bank is legal if we can show that the charity put the money to better use than the bank would have. One of the things that makes this also difficult, though, in trying to choose between the two approaches, is that we lack a general definition of harm to competition that's independent of the welfare effects. And defining competition purely in terms of welfare effects has its own set of problems. I think this is really an important area where we collectively need to do a lot more thinking.
Michael, Tasneem, you've walked us through a lot of analysis, a lot of ways of thinking about pricing, some of which may strike our listeners as counterintuitive. What are the key takeaways here for practitioners?
Let me start. I'll give you one. An important takeaway, I think, is that it really isn't about prices being too high or too low. It's about the competitive process.
I think another important takeaway is that we should avoid getting caught up in the formality of market definition. Instead, look at the specific facts and how competition works for the particular platform under examination. Now, obviously, a practitioner is going to have to deal with the formality of definition in litigation, but we shouldn't let it obscure the underlying analysis. And so that means paying close attention to how the platform's conduct on each side affects user behavior on that side, but also how it affects user behavior and welfare on the other side.
I guess lastly, I would say consideration of policies like MFNs are a good reminder that we need to take a market-wide view when assessing the effects of various platform policies.
All right. I want to thank Dr. Tasneem Chipty and Professor Michael Katz for what has been an incredibly informative look at how we think about pricing and platforms. I trust it was as edifying for our listeners as it has been for me. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.